Moving on, an early setback for the application to have former National Director of Public Prosecutions, Nxasana, reinstated. The North Gauteng High Court has dismissed with cost Nxasana's application for late filing of his answering affidavit. In his affidavit, Nxasana claimed that President Jacob Zuma had lied about how he had left the National Prosecuting Authority. Corruption Watch, Freedom Under Law and Council for the Advancement of the South African Constitution brought the court application. The applicants are seeking an order declaring Nxasana's removal from his post in 2015 invalid. Nxasana had reportedly accepted a 17 million rand golden handshake from President Jacob Zuma. This was after Zuma abandoned an inquiry into Nxasana's fitness to hold office at the 11th hour.
Saw the president's answering affidavit in 2016, and that's in February. In January and March of 2016, he meets with the applicants to assist them in the Rule 30 because he has knowledge of the correspondence that's missing. My lord, for two reasons. Again, the first reason is because he understood that it was not yet time in the proceedings for an answering affidavit to be filed, because the Rule 30 would be underway and there would be a further supplementary founding affidavit, and only thereafter would there be answering affidavits. So he understood that until the resolution of that process had taken place, that it would not be the opportune time or the appropriate time to file his answering affidavit. The second reason, he was unaware of the progress of the matters during the course of 2016. Of course, we can criticize him for not proactively trying to establish the progress of the matters. But given that he was not opposing the relief and was not, therefore, in the minds of the applicants as one of the active opposing respondent parties, he was unaware. He wasn't served with any papers other than the founding affidavit and Corruption Watch full. In the Case Act matter, he never received any papers until the 6th of April this year. And within a week, on the 12th of April, he had filed his answering affidavit in that matter as well. So yes, he is aware that the matter exists. He is aware in February of 2016 that the president's version differs from his own recollection of events, and that he would like to assist the court by providing his own version on oath. But he spends 2016 assisting the applicants in the Rule 30 to get all the documentation before the court. And then when he becomes aware that the matter is now proceeding towards set down, and which is when he receives the heads of argument in the Corruption Watch full case, and when he becomes aware of the full extent of the Case Act application, when he finally receives those papers for the first time in April, within a week of that date, he filed his affidavit.
The party who applies for condemnation for the late filing of a document usually does so only in his or her own interest. And those are usually the only interests in favor of the condemnation.
Yes.
This case is different. The evidence placed before the court by Mr. Nxasana goes to the heart of one of the issues in the case. The President says in a one-on-one conversation between himself and Mr. Nxasana requested to allow him to vacate. The only two people who would have personal knowledge of that conversation, if there was one, would be the President and Mr. Nxasana.